Let's turn to Lesson 19, which asks, how has the Equal Protection Clause of the 14th Amendment changed the Constitution? We'll start by asking you what is meant by the phrase equal protection of the laws in the 14th Amendment.
Well, let me answer you by starting with what it cannot mean. The Equal Protection Clause cannot mean that government cannot treat people unequally, because every law out there necessarily and usually, quite sensibly, treats somebody or something different from somebody or something else. A law that makes it a crime to rob banks treats people who rob banks differently, that is to say unequally, from people who don't. A law that imposes a sales tax treats people who enter into a transaction differently, i.e. unequally, from people who don't. So the Equal Protection Clause cannot and does not mean that government always has to treat everybody equally. What it means is that there are certain kinds of unequal treatment that are problematic. So, for example, a law that treats bank robbers differently from non-bank robbers is perfectly okay, but a law that treats African-American bank robbers different than Asian bank robbers is not.
What levels of government does it specifically restrict?
So the 14th Amendment's Equal Protection Clause quite pointedly limits states. It says, nor shall any state deny any person within its jurisdiction equal protection of the laws. There's no equal protection provision that textually applies to the federal government, but the U.S. Supreme Court, in a very important case, decided the same day as the famous Brown versus the Board ruling involving discrimination in public schools in the District of Columbia, a federal entity, held that the Fifth Amendment Due Process Clause, which we already observed applies against the federal government, contains an equal protection component that, in essence, requires the federal government to operate the same as states in almost, if not every situation with regard to equal protection.
What's the purpose of these restrictions?
The government ought not to be able to sort or classify or categorize people in certain ways. And you ask, well, what exactly are we getting at? What's the big point here? That's a bone of contention. Some people would argue that the Equal Protection Clause is designed first and foremost to prevent government from ever taking race into account, to make the Constitution colorblind. I personally don't think it's quite that simple. I think the Equal Protection Clause is about preventing government from creating classes or tiers of citizenship, from subordinating some people below others based on race, to be sure, but also other birth characteristics, things that are essential to who you are as opposed to what you do. So modernly, the Equal Protection Clause goes beyond race, and even within the realm of race, there's certain uses of race that might not create tiers of citizenship the way old-fashioned segregation did. So you have to have a theory for what equal protection means, and some people say it's about race and nothing else. Other people say, no, it's about subordination.
Can you tell us what's meant by the phrases equality of opportunity and equality of condition? Which of these is covered by the 14th Amendment?
So technically, the Supreme Court talks about the Equal Protection Clause in terms of equality of opportunity, by which I mean that the law has to treat people equally, but if they end up in different places with a neutral law, there's no constitutional problem with that inequality of condition or result. So sometimes we talk about this in terms of the difference between a law that creates a disparate impact versus a law that has disparate treatment. So, for example, a law that taxed blacks differently than whites treats them disparately and is problematic because it has that disparate treatment. But a law that says everybody pays a flat tax, even though that's going to affect blacks more harshly than whites because blacks have less money than whites, that's a neutral law that is equal in its facial applicability, but that just generates unequal results, but is not unconstitutional for that reason.
Well, do you think inequality of condition, that we allow it, undermines equality of rights? And how, if you do?
I think it can, because sometimes the equality of opportunity that we are enacting today takes place against a backdrop where the law was not equal for generations and generations. So I'll give an example. If we say today everybody pays a flat tax of 10%, that seems fair. And if we had done that 200 years ago, that would be racially neutral. But when you adopt that kind of law against a backdrop where the wealth of African American families and income of African American families is so much lower than the wealth of non-African American families, and the reason for that wealth disparity is that we used to have laws that formally treated blacks differently than whites, going back to slavery and Jim Crow and segregation, then, saying the playing field is level today without having taken account of the fact that people came into the competition with varying different starting points that were influenced by unfairness in the past, that rings hollow to a lot of people.
Aren't there some instances where disparate impact can be taken into account by the courts?
Yes, but as a general rule, not under the Constitution, only because of statutes that Congress or state legislatures have passed. So, for example, in one very important statute called Title VII, Congress tried to provide for racial equality in the workplace. And Congress said, if an employer is doing something that is racially neutral, but that tends to hurt racial minorities more than non-minorities, then the employer can't do that unless it has a very good reason for doing so. That's an example where disparate impact alone may make something illegal that somebody is doing. But that doesn't come from the Constitution, that comes from Congress.